Hi, my name is David P. Shapiro. I'm a San Diego-based criminal attorney, and I'm also the owner and managing partner of the law office of David P. Shapiro. My firm helps good people regain control of their future when charged with a crime. Today, I want to discuss with you burglary. Burglary comes in many shapes and many sizes and many forms. It's a lot more than just what you think, or what a lot of people may think when they think burglary. They think a guy with a ski mask breaking into a house when no one's around. Well, that's one form of burglary, but there's other forms of burglary. Generally, it comes down to you enter a house, a room, an attached garage, what have you, with a wrongful intent. And usually that intent comes down to either to commit a theft offense inside that structure or to commit any felony inside that structure. And most commonly what we see is the offense of residential burglary. Residential burglary, if proven, is a strike in California under California's 3 strikes law. Residential burglary, if someone was inside the house other than you or a co-conspirator or alleged co-conspirator, will be a violent felony. Doesn't mean anyone has to be hurt, just means it's a violent felony. And then the presumption is you go to state prison, and you go to state prison for 80% of that sentence. But no matter how serious or how minimal the punishment is of these varying types of burglary offenses, the main issue is, what was your intent? Now, your intent can be proven 2 main ways. Your intent can be proven directly based on, well, when you walk in a house that you have no business being in, and then you burglarize it, well, your intent when you walked into that house was certainly to steal. Or if you walk into a house to seek revenge on somebody that you feel wronged you and you get in an altercation with that person, well, your intent could be presumed your intent when walking into the house was to get into a fight or to commit an assault. It gets more complicated though when you're a guest of a home. Let's say, for an example, you're accused of stealing a piece of jewelry from your cousin's room. Well, maybe when you walk inside the house, you're invited in and you don't have any wrongful intent. Maybe your intent, if at all, came when you were inside the house or inside the room when you saw something and it was a moment of opportunity and you're believed to have taken that stuff. Doesn't mean you're guilty of burglary. So in that case, that's where your statements and your admissions come in to really sink your ship. So keep your mouth closed. Don't talk to the cops. Don't talk to the prosecutor. Don't talk to your friends or family. Certainly don't talk to the people who are accusing you of committing this burglary. So the intent element is key. That's usually your best defense, assuming it can be proven that it was you in the first place. So again, to summarize, burglary really starts on the low end of the spectrum. 459.5 is a new addition to California Penal Code, talk about shoplifting, which is part of the burglary subset. And it could go all the way to hot prowl residential burglary, which is a presumptive state prison case and a violent felony. If you find yourself on either end of the spectrum or somewhere in between, you need our help. If you want our help, we encourage you to give us a call, 619-295-3555.